let's give Mugambi 1 minute. As we're giving Mugambi 1 minute to join, we can start with an introduction from the panel. And I'd like to start with Burju Kile. Hi, Burju. Could you please introduce yourself for our guests today?
Hi, Melissa, and hi, everyone. My name is Burju Kile. I'm a senior fellow at the international at CG Center for International Governance Innovation.
Thank you so much, Burju, for introducing yourself. We also have Dr. Emily Jones from Oxford. Hi, Emily.
Hi, everyone. It's lovely to be with you all. I'm Emily Jones. I'm an associate professor at the School of Government in Oxford and an economist and politics person by background. So it's nice to have all the lawyers in the room as well. And I work on basically on digital trade from a public interest perspective.
Thank you so much, Emily, and thank you for breaking up this group of lawyers. Next, we have Jade McCory. Hi, Jade.
Hi, Melissa. Hi, everyone. So I'm Jade McCory. So by way of background, I'm a lawyer, but I wear different hats from time to time. So I generally associate myself as a technology lawyer. So anything that intersects with technology is a very big interest for me. So things relating to digital trade is also one of those areas. So really looking forward to this and having this conversation with everyone.
Thank you so much. And once again, I'd like to introduce the chairman himself, Dr. Mugambi Laibuta, of the Data Governance and Privacy Society of Kenya, which is the co-host of this event. Over to you, Dr. Mugambi.
Thank you so much. I think you can hear me. For some reason, I couldn't unmute myself. But okay, so thank you, everyone. So we are going to have an interesting and interactive sessions. As Dr. Melissa has indicated, please put any questions that you may have it in the Q&A, and we'll deal with them as we proceed. So, we want to know what is this digital protocol. I think we just straight off the bat, Melissa, perhaps you tell us this African digital protocol, what is it about? So I read recently, Professor Gavi wrote something about this digital protocol. And actually, the title of his article is that the AfCFTA digital trade rules are not fit for Africa. And as I read that, I was like, oh, wow, this is a process that has gone on for a while. Most of us have a draft or a leaked draft of the protocol. I don't think anybody has seen an official draft, but the hope is that what was passed at the AU did not deviate very far from the draft that we have. But just to start us off, Melissa, what is this protocol all about? What does it provide for, and what are some of the features that you like to share?
Sure. First of all, the Digital Trade Protocol is part of the Africa Continental Free Trade Agreement, which governs the Africa Continental Free Trade Area, which is the largest free trade agreement in the world and free trade area in the world. It has 55 countries and 8 regional economic recs like ECOWAS, EAC, COMESA, SADC. So this is a big deal. It's a really big agreement, and we've heard about this since 2020 till now, and we're getting to see the different components of what make up this free trade area, which includes the Digital Trade Protocol. The other protocols include the Investment Protocol, which is still under negotiation, and the Intellectual Property Protocol, which has undergone negotiation already, and also drafts of that are floating around. So everybody is talking about a draft because free trade agreements in their very nature are normally negotiated in secret, right? And they basically govern how member states that are part of the agreement will trade with each other and with third parties. So like its name suggests, this protocol gives principles, common principles and rules of how member states, being the African member states, will conduct digital trade with each other and with other third parties. And it's interesting to note that there are different parts within this protocol that include data governance, that include digital identity under the facilitation of trade part, that also include business and consumer trust, which is a very interesting title or topic to have in a protocol. It also talks about facilitating digital trade and digital trade inclusion. So it is, I don't want to say a comprehensive document, but it sounds like a comprehensive document, and maybe I'm hinting at the conversation. And basically, it attempts to touch on everything around digital trade that would occur between member states, including emerging technology. So the key provisions of this is the treatment of digital products, data governance, market access, and consumer trust, which we'll have different members of this panel speaking about here today. For me, the really interesting part is on source code and on data governance for obvious reasons. And I'm hoping that we'll be able to delve into that. So that's a brief idea of what this digital trade protocol is. But we should remember that it anchors itself in the AU agenda, 2063 agenda, but also anchors itself in the digital trade transformation, or rather digital transformation agenda, the 2020 to 2030 agenda of the AU as well. So essentially, it's just the AU trying to ensure that its membership is thinking about moving trade from the analog to the digital. And then we can have a conversation as to if it's doing a good job in getting us there.
I like that you've been cautious in calling it a comprehensive document. But just a follow-up question. Why is it a follow-up? I mean, for those who perhaps have not engaged in trade agreements, why are such agreements shrouded in secrecy? Why is it that even the draft that we are reading is a draft that was leaked by someone? Is it the typical, because I've worked, I mean, most of us have even seen government before, the Kenyan government, where you hear there's a statute being discussed and it's hidden, somebody leaks a draft, you're not sure whether it's the official draft. So why all this secrecy?
That's a good question. And this is a norm within the trade circles. And I'm really happy to have Emily and Boju jump into this. But my understanding of it is that the negotiators normally say that they need this secrecy in order to move the text along between the different members. And if the text is out in the public, then there'll be all these voices that might not lead to a consensus. I don't think I thoroughly agree with that. I actually think that they should be public and that all voices should be included in within the negotiation space. But this is actually what happens in all trade negotiations. So if you think about NAFTA, which we'll hear about, that was also negotiated in secret. If you hear about what happens at the WTO, half the time things that are being negotiated there are done in secret. So this is sort of like a custom or a norm for trade agreements and how they're handled. And I think it's a good question about what does that mean for public participation? Because it means those who have a higher bargaining power and better lobbying standards within their states will have better representation of their citizens. And those that don't have good bargaining power and don't have good representation of citizens at the state level will not actually reflect what needs to be done at that level. So that is the answer that I have, and I'm willing for others to jump in. But yes, it's a custom that trade agreements are negotiated in secret in order to allow for consensus to happen before then they're released to citizens to then begin the public participation process.
Okay, thank you so much. As you can hear me, I think there's a fluctuation of my network. But then we'll go to the next question to Boju. What kind of services are affected by this trade agreement? There's some that Melissa has mentioned, but essentially, what services will be affected?
Sure. Yeah, let me. But before I want to before I talk about what kind of services or goods affected by this digital trade protocol, I just want to complement what Melissa said. Like, you know, I mean, there are exceptions. The trade agreements are negotiated in secret because it works well for for the trade negotiators. But of course, like the lobbies, like the corporate lobbies, which are the main drive behind these agreements, they always find a way to you know, like way to know influence these agreements. But there are also exceptions, like, for instance, European Union publishes its negotiation text, and it didn't happen over the night, but there was a really big pushback against this secrecy during the trade agreement negotiations between the EU and the US, and the European civil society demanded transparency, and the Europeans, like European Commission, like this changed its policy, and now European Commission publishes its negotiation text. Unfortunately, it's still an exception. Some of the texts at the WTO, like in the WTO negotiations, get published, but still, like, the countries can decide. But when it comes to the trade negotiations, like, there are bad practices and there are good practices. Good practices, publishing the text so the public know about what you have been negotiating on behalf of them. But the bad practice is secrecy, and we call this as corporate secrecy, because corporations have access to the text. And unfortunately, many countries have been following the bad example instead of a good example. So coming back to the question about what this protocol covers, so the protocol defines the digital trade as let me see, it covers the goods and services that can either be digitally and physically delivered. So it can be any goods or services that bought online, and anything you can think of. But that's what's in the protocol. But I think the far-reaching implications of this protocol is more important than what's in the text. It covers all the goods and services which are online, but the implications are more serious than that. And when I was preparing for this webinar yesterday, I did some research. I just wanted to see what people have been saying about this protocol, because I have to say there isn't much going on. I mean, we've been hearing about this protocol, and I was asking Melissa, a couple of months ago, hey, have you heard about this, the digital trade protocol? And she was like, I know, but we don't have access to the text, and we don't know what's going on. But in policy circles, people have been talking about this, and it's interesting. There was very limited access to the text, and I think only few consultants and few government officials had access to the text. And even they agreed on the text, and as we said, as Melissa mentioned, we don't know we haven't seen the final version. But there are all these commentaries on the internet written about this protocol, written by big law firms. And one of the commentaries is very interesting, because I think it really well addresses what the protocol covers. And I'm going to read it. This is written by a big international law firm, and they are telling their clients, technology companies, multinational technology companies, that this is relevant for their work. This is not intra-Africa protocol. This has implications. So I'm just gonna read what they wrote, and I think it will give us a better idea about what this secretive protocol is about. So why this protocol important for technology companies operating in Africa? The digital protocol covers important areas such as data governance, data protection, cross-border data flows, online consumer protection, cybersecurity, and emerging technologies, including artificial intelligence. For multinational technology companies that operate in several jurisdictions across Africa, this is particularly important given the historic and current challenges relating to limited regulatory and commercial interoperability between jurisdictions, high costs of compliance and transaction costs, and the limited access to regional markets. So the answer to your question is, this protocol is relevant to digital policy, digital economy in Africa, and it goes beyond what's written in the text.
Thank you so much. You've mentioned big tech, and I think that's a debate we'll have later. I mean, what the role of various stakeholders is and who creates the narratives and who informs the text. But before we get to that discussion, I wish Emily tell us what will the implementation of this protocol look like? How, I mean, when you compare with protocols in other regions, perhaps in the EU, in the South Asia Pacific, in Asia, how will the implementation of this digital protocol look like?
Thank you so much. It's great to be here. I just wanted to chip in, if I may, very briefly on the transparency and precedent setting question. So I fully agree with what's been said on transparency. And the EU is a really interesting example of a country or a region that's moved towards transparency. And the Brexit negotiations, which were incredibly far-reaching, were entirely done on the EU side transparently. Right? So we do have that precedent. And I think we also need to think about not only the voice of stakeholders, but the voice of parliaments and legislative branches as well. And been working a lot with the UK government and the UK Parliament, and they have very little oversight of anything that's happening. So I think it's really important to think about engaging parliamentarians as well in these processes of ratification. On this, how does it stack up? So I've recently looked at all the recent digital trade agreements, and there's a lot of complexity, but I think, let me just give you my sense of a sort of broad narrative of where digital trades come from and how to situate what we've seen from the African Digital Trade Protocol within that. And as you probably know, there are negotiations underway at the World Trade Organization, but they've got stuck. And one of the reasons they've got stuck is there are quite divergent approaches to regulating digital trade. So as Bertu has mentioned, and Melissa too, there's a lot at stake here in terms of how we govern the increasingly digitalized global economy. Right? Our economies are digitalizing very rapidly, and it throws up a whole load of policy challenges. Happy to go into them, and we will. But I think what's Anna Bradford's work really helps us think about this as three big different ways of regulating. So you've got the US model, the EU model, and the China model. So she talked of three big digital kingdoms, all with quite different approaches. And if we think historically where digital trade has come from, it's from the United States. So if you like, it's the United States push into this space. And I think that's important because, and again, we can delve into this, but the EU and China have taken a different approach and have been less willing, if you like, to cede a lot of the regulatory autonomy that we see being ceded with the US model. So let me just dig into a little bit into the US model, and then a second wave. So I think we saw a wave of digital trade agreements that came from the United States, and the shorthand for many of us is that they were very much drafted by Silicon Valley. So you sort of had the United States Mexico-Canada agreement, the USMCA, you had TPP, Trans-Pacific Partnership Agreement, in the early days before the US withdrew. You had US-Japan, and they were very much shaped by the interests of the large technology companies. And already has been mentioned, but I think data flows in particular and protections, extending protections over intellectual property around source code and algorithms were two really big salient areas. Then we had a second wave. So we saw the United States kind of step back from free trade agreements, and Biden has continued that trend, and others have kept going in this space. So we've seen a second round of digital trade agreements that actually essentially built on that first wave. So they replicate a lot of what is in the United States approach, if you like. But then you've had Singapore, Chile, New Zealand, Australia, South Korea have come with a second wave that essentially leaves more or less intact the US model. And I think the US model, as I've said, sort of has shortcomings, I think, from a public interest perspective. They haven't necessarily addressed those shortcomings, but they have expanded the scope. So then we've seen a lot of new issues added in, including things like digital identities, last mile logistics. And so what's interesting for me is that while I've yet to go through really line by line and compare every single provision, the current Africa Union Trade Protocol or Digital Trade Protocol picks up a lot of the new issue areas. So it's quite expansive. So in terms of its breadth and how comprehensive it is, it's up there in terms of coverage. However, and this is where Bertu has already mentioned these annexes. So a lot of the detail is left to the annexes. So it's really hard to tell how precisely it compares, because if you look at a lot of the provisions, say, subject to an annex that we haven't yet figured out, and certainly there's no draft in the public domain. So we're not yet clear as to precisely how constraining, if you like, some of the provisions are.
And for these annexes, what is it that we should look out for? Because I think it's strange. I mean, I think, Bourju, yourself, you've mentioned the fact that, for example, the EU was very transparent in discussing trade issues. The Brexit documents or public documents. So when you think about these annexes, because of this draft protocol that we have, it says that at the end, there will be annexes that will give the details of how to implement some of these issues. But what should we look forward to? I mean, what should we pay attention to in the drafting or in the enactment of these annexes?
That's back to me. So I think, I mean, the
Yes.
crucial question is, for example, on areas like, I'm just looking for the data governance. So if you look at Article 20 on cross-border data transfers, it says subject to an annex, right? Data shall flow, essentially, right? And then there's an exception. But the question is, what is this annex going to tell us? So for those of you working on data governance, obviously a lot of governments, and I'm not so familiar as you all are with the details of what African governments are doing in this space, but many governments are restricting data, right, in certain ways in terms of how it crosses borders. So is this annex then going to carve out massively all of those regulations? Or is it going to be a very narrowly drafted annex that essentially says data shall flow except under extremely limited circumstances? So we're yet to see, if you like, the scope of the carve out and the exceptions. So the general commitment is very much in line with the United States type of draft. The data is going to flow freely, but we're yet to see the scope of the exceptions and carve outs.
Yeah, and just a follow-up, I think you're raising very interesting issues. Because you mentioned, I mean, and we've seen this practically. In Africa now, there is the EU aspect. We have EU development partners, we have EU companies that are pushing the fundamental rights aspect, because when you look at GDPR, it's very human rights specific. But the US is about free flow, it's about trade. And then you find the China model, in my view, it looks more about, it's a lot about localization. It's about protecting the Japanese economy. So what kind of power play will be there when we are discussing this annex? I think, Emily, any idea how, or even
what's fascinating, if you look at what the EU signed up to, it has a massive carve out for everything to do with personal data protection. And it doesn't put in these general commitments on we will let data flow. Right, so the EU's firstly not letting it, it's not tying its hands in terms of its ability to restrict data flows, and it's saying it's put in a huge self-judging carve-out in most of its trade agreements to say, and we're going to allow ourselves to do whatever we like in the name of protection of citizens' privacy. So we're not seeing that model replicated here. What's interesting, I think, for a lot of African governments is if you've got GDPR and the type of EU approach nationally, is there, and that's a question for all of us, I think, a contradiction between the type of commitments that are then being made at the regional level and the type of things that governments are trying to do at a national level?
Yeah, and I like to follow up on what Emily said, and I want to bring the discussion back to the negotiation process. I mean, this was the problem, this is the problem with the negotiating these agreements behind the closed doors. And we need that this protocol was like, I mean, the African countries were negotiating this protocol, but we didn't know the details. Not many people had access to the text. And then when the text was leaked, because all our assumptions were based on the leaked text, but it has been confirmed that the final version is not, it's not different than the leaked text. We just realized that, like, like the provisions, like in the digital trade protocol, are the exact same provisions that the recent, like, USTR, like United States Trade Representative, withdrew its support for. These provisions are not new. As Emily mentioned, these are the first wave provisions which were developed by the US negotiators for US big tech companies. Back in the day, like, I mean, this started with the Trans-Pacific Partnership Agreement 10 years ago. But the thing is, the US position has changed. Since the Biden administration assumed office, the domestic conversation in the US has adopted a more critical view of the tech industry. And the Biden administration takes a holistic approach to digital policy and digital economy. That's why they wanted to synchronize the trade and digital policy. And that's why, like, the USTR withdraw its attributions in the WTO, the same exact, its support for the same exact provisions, saying that, I'm sorry, but this is a digital governance issue, and we can't be really part of discussion at this stage without having the domestic discussion. We need to give the policy space for our Congress and for our administration. So these rules are no longer the US positions. This is the first wave. These are the outdated rules. And since, we had no idea what was going on with the African Union and African Digital Trade Protocol, we ended up with these outdated provisions, which work only for big tech companies. They didn't, many people say that, oh, these are American provisions. These are not American provisions. These provisions don't work for American people. And USTR Catherine Tai made it clear that, because there was an outrage when USTR withdrew its positions, and everyone was saying that, criticizing the USTR and the Biden administration for withdrawing its support for this provision. And USTR Catherine Tai said that, I'm sorry, I work for the Biden administration, and we work for American people, not for big tech companies. I think that very well clarifies what is wrong with these rules. But it was a disappointment for us to see the same exact rules in the African Free Digital Trade Protocol. And as Emily mentioned, the text is they copied pasted from the USMCA, from the TPP, and then they put the annexes there, and no one knows what's going to be in the annexes, and there will be discussions of the annexes, and probably it will be behind the closed doors. And this is not about intra-African trade. This is about, digital trade. This is about, as I mentioned in my introduction, this is about the privacy. This is about data protection. This is about AI regulation. This is everything about the digital policy in Africa. And it's very, very disappointing to see that everything is happening behind closed doors. Even in the US now, there is an interagency conversation. There is a conversation which includes the industry, but also civil society organizations. Things are changing. And European Union is a different example. And as Emily mentioned, they really set the precedent high. There are problems, I have to say. If you ask Europeans, they will tell you, they have their own concerns. But still, I think that's the model we should follow, especially for the annexes. It's not over till it's over. Yeah, you copied, pasted these provisions in the protocol, but still, we can develop, better annexes, better exceptions, better carve-outs for the people of Africa, not the big tech companies.
Thank you so much for that, Emily and Buju. So I wish to ask Jade. Jade, you provide advisory services to public and private sector, and how do you see this affecting the business of some of your clients? How will it pan out? And what Emily mentioned, that they potentially, because nationally a lot of states have adopted the GDPR model to data protection. Yet this protocol talks about free flow of data. So Jade, how do you see this playing out, especially, for example, in Kenya?
Yeah. Thank you so much for that, Mugambi. And there's also been quite a number of interesting insights. I think context will be very important, especially for us, because when you're looking at, let's say, the different regions, and I think when you're looking at it that way, you find that we are, even as Africa, at different steps or at different places when it comes to, say, things such as, say, some of the things that have been contemplated under the protocol. And a very good thing that I think Bushu had also just highlighted is that this is not just about trade, it's digital trade. And when you're even looking at even quite a number of these laws, or a lot of the regulations that have been coming about, even from different regions, it's very hard to say that they're not going to impact, say, areas outside of Africa. There's an extraterritorial application that has been edged in a lot of these laws and regulations in different regions when it comes to, let's say, things that touch on this. And I know we also deal a lot with, let's say, our Asian and our Europe counterparts. And even when we discuss some of these things, be it, let's say, the American approach or the Europe approach, because I know at some point, even when we're having this conversation, we're having that conversation in terms of, let's say, the DSA and the DMA, so the acts that govern, or the ones that sort of guide some of these things from a digital perspective in the context of Europe. How is that also shaping us? So we also have to look at it from the point of view of this is also going to impact a lot. It will also impact how, let's say, entities will also want to engage with, let's say, Kenya and Africa at large. I think my greatest concern is also looking at it in terms of definitely the annexures will likely also take a very political stance because there are different interests, and that cannot be removed from the very nature of how the negotiations will take shape or even how they're sort of unfolding. But looking at it in terms of, so what's the interplay between, let's say, what Kenya can actually even achieve at the local level in terms of, let's say, some of the things that have been contemplated under the digital trade protocol, even as we are sort of even interacting as the different African countries. Because if, let's say, Kenya enacts, because I've seen very general blanket provisions within the protocol that provide that, hey, we'll possibly need to have, or the different state parties will need to have in place, let's say, consumer protection laws, data protection laws. But we also need to, these laws, these regulations also going to come from this common place? Or is it actually going to segregate us a lot further? Because we also saw this when we're talking about even the services protocol. Because when you're looking at that, you find that data protection in itself has been contemplated in different texts, even under the AfCFTA, even under the different regional economic community agreements. And we're looking at it in terms of there are different things, there are different moving parts that we would need to consider, even as we look at the digital trade protocol. And I think it's a very good opportunity for even Kenya and Africa at large, because this will be a broadly African conversation, but looking at it in terms of even as perhaps those who are negotiating these agreements, what is the value that this will take? Because if this is being negotiated under the AfCFTA, and we've had, let's say, similar discussions relating to other protocols, such as, let's say, the investment protocol, the intellectual property protocol, and we've seen that sometimes, even when you're looking at, let's say, the way different countries will bring in their ideas, sometimes there are also disconnects in terms of perhaps even where we are in terms of the different laws. So I think my greatest concern is that for Kenya, and there's that concern where how does this particular protocol even hamper or enhance how we'll actually go about our digital trade? And looking at it in terms of, we do have these consumer protection laws, we have our data protection laws, we have our Computer Misuse and Cyber Crimes Act, which will look at now, let's say, cybersecurity. And we also have these other laws, which sort of in different ways also cut across, let's say, areas such as data governance. So how will this even be impacted in the context of, let's say, having a protocol? Will it take a silent approach, or will the annexures also provide some positive actions that the different states will need to take, even as we look at it in terms of how we are even trading with each other? So I think that's just perhaps a very broad view, and I know we'll also delve into the very particular areas such as competition and others. But I think as an onset, those are some of my views.
Thank you so much. There's something I'd like to ask Melissa. I mean, if there's a conflict, I mean, I think Bojo, Emily, and Jade have talked about the differences between local laws and this protocol. So what happens, Melissa, what happens if the annexures now come in and the annexures are not in sync with our local laws, like, I mean, our Data Protection Act, our Computer Misuse and Cyber Crimes Act, and also remembering that data protection for us emanates from the right to privacy and Article 31. We have a provision in the Constitution on consumer protection. So how will this play out? What will rank higher than the other? Melissa?
Yeah, thanks for throwing that question at me, and I'll also throw it across the panel, because there is already conflict. If you look at the articles on cross-border data flows, on computing localization, already that's in conflict with our Data Protection Act. And the language of the protocol says shall. I was reading through the language, and each of these articles says the states shall, apart from one which says shall endeavor to. And I've actually made a note. I said, I was wondering, why did they say shall endeavor to in this one article, but everything else was shall? And I just need to find it. I'm gonna find it because I made a note of it, and I'm like, why is it this one? It's just an endeavor. Anyway, it had to do something with innovation, I think, but everything else is very prescriptive. The language is very particular as shall. Now, being members of this trade agreement, it means that international law takes into place, that you have to implement what you have signed on to as a member state. And the obligation is the state to harmonize between the national law and this agreement, right? Not only are you to harmonize it, but you also ensure that you have all these most favored nations and fair treatment of other nations as well start kicking in. So essentially what it means, and which is the question that Burju had asked, is that it's creating work for the African states to harmonize their national legislation with what is happening with this free trade agreement. And the question is, this is not a typical trade agreement where we can rise up and say, the US is forcing us to do, etc., or a foreign entity is forcing us. This, we are doing it to ourselves. It leads me to ask questions about the capacity of the negotiators from the Kenyan side. Did they not notice that there's an issue here about these aspects within our national laws? There's also a question around sovereignty of nations, and I don't get too much into that, but they create space and say that nations, after they put in the first shall, so for example, they shall be the free flow of data across borders. The second element comes in that says this shall not take away from states coming up with their own national laws that will not take away from the possibility of digital trade. We are going around in circles. So I'm actually quite interested to see how that will kick in. I already noted that conflict. I noted the language. The question is, we freely negotiated this. Nobody forced us to do this. We went in with our eyes open and agreed to do that while we knew our national laws are different, which seems to signal to me that we are going to have an amendment of our national laws in order to be compliant. Because remember, this is an AU-led strategy, and our trading partners are within Africa as well. We cannot abandon that process and say that we're not going
just a follow-up. Look at it this way: the African Union Convention on Cybersecurity and Personal Data Protection. It's less than let's say less than 20 countries have signed up. Even in West Africa, we have the Act on Personal Data Protection, and not all countries have implemented. So what is it that will force people now? I mean, will force these countries now to say, now this one will take seriously. We've not been taking the Malabo Convention seriously. We've not been taking the ECOWAS or the Act on Personal Data Protection seriously. But this one, we resolve that we'll take it seriously. What will be the motivation?
So that's a good question. And I found the article 18 on infrastructure. Nobody's talking about digital public infrastructure. That is shall endeavor to. Yet digital ID is a shall. And you already know the situation about digital ID in Kenya. So maybe, anyway, that's another side commentary. What is the difference between this and the Malabo Convention? I think that the difference here is that word trade. Trade, commerce is the difference. And that is what will really force people to comply. Also, if you look at how the AfCFTA trade agreement itself has been adopted, it moved like really better than the Malabo Convention, right? And this is a huge amalgamation of different things. So that it's really that aspect of commerce and trade that is going to push. And maybe we should also ask ourselves, who else is interested in this protocol and this agreement actually getting into force properly and being fully implemented? And some of those questions have been answered in terms of where did the text come from? Where is the genesis of this text? Who is this text benefiting, right? So I think this is not any typical free trade agreement. Number one. Number two, because commerce is involved, commerce between states. Even in Kenya politically, look at what we've been having for weeks, a question of who is going to go to the AU. why is there that question about who's going to go to the AU to represent Kenya or to represent?
So who do you think
AU?
will go? Anyway, that's just beside the point.
So I mean, it already shows you that the interest is so high that you're actually talking about not only complying, but actually physically vying, as in being present there.
I think with what you've said, I wish to go back to Emily and ask who does this protocol, the document that we have, who does it benefit really? And I think there's somebody on the chat, on the Q&A, who said that the final version just has, they only removed brackets here and there, but the document is fairly the same. But Emily, when you look at this document, who does it benefit largely?
Yeah, thank you so much for that question. And I think the global economy is digitalizing, and I think rightly a lot of African governments, and I'm probably trying to figure out, how do you maneuver in this space? How do you become competitive? How do you foster firms that are going to work across the continent? And one of the challenges, I guess, is that if you've got a lot of very fragmented markets, it's hard to see how you can kind of grow your own digital company. So on one hand, you could argue that creating a digital single market right across the African continent makes sense in terms of trying to create market opportunities, right? So that's the kind of the logic of the argument of why you might want to do this. I think the but is that unless you've got the kind of, it's two things. What's the model to which you're converging on? So is the US type of model where African countries want to converge? So if there's this push for harmonization, is that the right model to harmonize around? And the second one is that if you've got large technology players from other continents that are then going to play in this new market that you're creating, how is it that you're going to support your own domestic industry to benefit? And how is it that it's not going to be just the external companies coming in that benefit, because they've already got the economies of scale, they've already got the technologies. And I think that's the bit that's missing in all of this. Melissa mentioned digital public infrastructure. And until you've got a lot of the kind of complementarities around, it's very hard to then grow your own domestic businesses that are going to be able to compete in this market. So all that you've done then is open up the market. You've not done much to help your own domestic digital economy players grow, and you've created the space for others to come in and play very nicely. Thank you very much. Right. And one of the things that's missing, and it has been missing in all of the digital trade agreements, is any reference to making sure that these markets are competitive. Right, so one of the biggest challenges globally is that we've got digital markets that are incredibly concentrated, and there is no reference in any of these trade agreements to actually addressing competition in digital markets. So it's a huge lacuna. So the models, essentially the model that we have is one that opens up and liberalizes without providing the balancing commitments to make sure that markets are contestable, without providing the digital public infrastructure and the skills and support that you can grow your own local companies. And I think on the consumer and citizens' point of view, doesn't also provide robust data protection, consumer rights, etc. So you've got quite an unbalanced model, and I think that's the big risk.
Thank you for that. And maybe just a follow-up and ask Buju this. So are we going to see, I mean, it's quite a direct question, are we going to see these multinational digital players now coming in and setting base, let's say Nairobi, Johannesburg, Cairo, and saying, now we are an African company, so you need to treat us the way you treat everybody? Is it something that potentially could happen? And how will that play out? Because Emily says there'll be a big disparity because they do have the infrastructure, the technology, and what happens now to the local, maybe the local developers. You may have small micro enterprises that also are developing technology, but now they have to compete at the same level with these multinationals. So Buju, so are we going to see these multinationals now come and having registered office say, now we are a Lagos-based technology company, or we are a Kinshasa-based technology company? Is that a possibility?
I think they are already doing business in Africa, right? In Kenya, like, so they are already established. They are already in the market. So I think, you know, I think the most important thing for them is to have these rules, like, you know, I mean, coming back to the question about why trade agreements, why trade agreements are so important. Trading agreements are important because they are binding, you know, and the convention is also binding, but trade agreements are enforceable. You can really enforce the trade agreements, you know, because you can really, like, and we've seen this over and over again, like, you know, for many years, and this is not a new issue. Like, I mean, like Melissa and I both have an IP background, you know, and that was the same thing, you know, with the IP rules, like they are binding and enforceable. That's why like the companies, like the big companies, multinational companies love trade agreements, because, you know, the trade agreements like liberalize the market, or like in the case of IP, the trade agreements introduced like, you know, strong IP protections, which were in the interest of like big pharmaceutical companies or big like content companies. You know, they love this agreement because they are binding, but they are also enforceable. So like, you know, and I've seen this for many years when I worked on IP policy. Like anytime like the countries, they wanted to change their IP laws, like, and introduce the flexibilities, which we call the TRIPS flexibilities, which are already in international law, which are widely recognized. Like it's in the TRIPS tags. Like they receive pressure not only from the companies, but also from the USTR, United States Trade Representative, from the European Commission, telling countries, no, you can't really do that, like, because you have these trade obligations. And I think that's the enforceability piece of it. And in the case of digital trade, like, and I remember I was at a conference many years ago. This is like a decade ago, and it was about digital economy, and people were discussing like, you know, how we can regulate the digital economy, like what is the pathway for like global digital rules. And you know, one of the commentators, and I think he was like he was from the tech company side, and he said that like, yeah, we can go to the UN rules are good, they are binding, but like trade rules like the WTO is better for us because those rules are binding plus enforceable. Like, you know, we can really get the rules enforced if we go to the trade agreements. And that stayed with me all those years. And I think I can really see that big picture. You know, yes, trade rules are binding and enforceable, and the trade commitments, as Melissa mentioned, you know, they come like, you know, typical trade rules are like each party shall allow, or like no party shall restrict information flow, shall, and these are the hard commitments, you know, and they come with exceptions. The exceptions, like, you know, the exceptions place like there is a rule and an exception what countries can do. The exceptions place on how domestic regulations may interfere with these rules, and that's why the exceptions become very important. And that's why we've been having that discussion in the US, because the USTR realized that the exceptions in the, you know, US trade agreements are not working for the realities of digital economy. You know, that's why like we are having that conversation in the US now, like finally, like, you know, to find better exceptions, you know, because like without better exceptions, these rules are not working for anyone. That's why, like, you know, it's impossible to get like the rules right in trade agreements without thinking the exceptions. And the
As you
question,
speak, just as before this point,
yeah.
Rachel has asked, you've talked about the enforceability, so which means that the dispute at some point and people wanting to enforce this protocol. How is that mechanism? How is that mechanism of enforcement? How that paint us a picture of like maybe Kenya has decided to go rogue and not domesticate, and somebody at big tech company wants to make a complaint. How will that play out? What avenues will be available?
I'll give you an example that I seen this, you know, many years ago. As I said, my background is in intellectual property, and for many years I worked as an access to medicines lawyer, and you know, we've seen this trend. Like there was like late mid to 2010s were like the peak of those like multilateral trade agreements, the TPP and others, like, you know, RCEP, like, and every country was trying to join these agreements. And these agreements came with like, you know, with a very stringent IP chapter, which was limiting like, you know, what countries can do in terms of access to medicines. And it had very it had results like they would have resulted as like very high prices, and this was the case in other US free trade agreements. And I was talking to one of the officials from a country because they wanted to join the TPP, and I was like, why do you want to do that? Because, you know, it's just like there is this IP chapter, you're going to pay double, triple for your medicines. And he told me that, look, I need, we need better access to the US market, because the trade agreements, like they come, like, I mean, at least that was the old trade agreements, like the TPP and RCEP, like there was a market access component of it. That's why countries really prioritize the trade agreements, because they get some benefits in terms of market access. So when countries didn't really comply with their obligations, or when companies thought that they were not complying with their trade obligations, they complained to the USTR and they said, like, hey, this country X, like they introduced a new law, which promotes access to medicines, but this is against our free trade agreement. Do something. And the USTR and the other trade, I mean, this is not only the US, this was not only the US thing, like it was the same thing for the European Commission. We're like telling countries like, oh, you can't really do that. You have this trade obligation, that's the enforceability part of it, right? So like it's binding, but if you don't enforce it, they cut your market access. So there's new trend of trade agreements which don't come up with market access. And it's always a question why countries want to join those trade agreements. And that also, like, that I think that's one of the reasons is digital trade is so popular now. Like, everyone wants to have a digital trade agreement, like, and everyone wants to talk about digital trade agreement. So in the case of like the AfCFTA, of course there will be consequences, because it's part, the digital trade protocol is the part of the AfCFTA agreement. So that's why the enforceability is it becomes very important. And that's why they put all these provisions in digital trade protocol of the free trade agreement. So, I mean, Melissa can tell you a little bit more about like the AfCFTA system, like, and all the obligations there. But trade agreements are serious, That's why like every industry, they want, trade rules which protect them, which, liberalize the market, or which introduce like stronger protections for them, because they are binding but also enforceable.
Thank you so much. I want to move. There's a question about privacy. Whether you wish to add on that? Yes, please.
There is a dispute resolution article within the protocol. It is the shortest article in the protocol. That should tell you something. It then refers to the dispute settlement protocol of the AfCFTA, and that refers to it's state to state. It does not allow private entities to be part of the dispute resolution system. And there's a board, there's a panel, and there's a whole procedure of how disputes can be instituted against different states. So that already tells you that there is an intention to enforce the provisions within the protocols and the agreement itself, and the provision, and there's a particular protocol that will ensure enforcement of those provisions. So that adds to what Buju is saying, that yes, if you do not meet the terms or the provisions of the protocol or the agreement, there is a dispute resolution mechanism that flows.
And as you mentioned, it's state-to-state dispute resolution. Okay. And then you've mentioned the board. I mean, that segues to a question that I want to ask Jade, because there's a question on the chat about whether it will be now a possibility to have an African, like in the EU, we have EDPS, we have EDPB. Are we likely to see this in the annexes? And how will this affect the data subject on the ground, if I may use that word? How will this pan out? Because there's been a lot of discussion about data protection authorities across the continent saying that they want to harmonize, they want to have one uniform regulatory. Will this be the opportunity to do this, Jade?
Okay, so thank you so much for that, Mugambi. And I think this whole conversation on harmonization, it dates back to, I think, when we started having the conversation on Malabo. And even after now, let's say the AfCFTA agreement was actually ratified, came into force. And I think a very important place I would actually want to reference is also looking at it in terms of how the different protocols, including this one, have also contemplated some of these areas, including data protection. Because the very first protocol that spoke to data protection was the services protocol. And in that particular protocol, it actually provided for an exemption, a general exemption from data protection, that now states would now perhaps now have their laws sort of guide this data protection conversation. Yet we are having this whole instance where the way the digital trade protocol is approaching it, we're sort of not sure whether the emphasis is going to be placed on the state to actually provide for, let's say, its particular state in terms of how it regulates data protection, or if it's going to move towards its harmonization. So there is some sort of, it's almost like a bipolar approach in terms of how the protocols are providing for some of these related areas. And my greatest concern is also, even when I'm advising some of my clients and the general laws that currently also ensue between the different states, when you're looking at, I'll give the example of Kenya and Uganda. Uganda takes a more nationalistic approach to, let's say, the protection of even data subjects. It does not talk about the location of the data subject. It talks about the nationality. So you already have such nuances. You have, let's say, laws in Morocco that have existed for decades that provide for data protection in a certain way. Then you're looking at laws that perhaps have been sort of carved out because of different influences, because the way the Anglophone countries have drafted their data protection laws and the way the Francophone countries have actually drafted it has also changed, and you can see very blatant nuances when it comes to the two approaches. So when you're looking at the digital protocol, and an opportunity that I thought would actually come about is a bit more guidance in terms of what exactly are we going to, how are we going to practically approach this area? Because it's very easy to say that, hey, states are going to take this particular approach and that they must, and let's say, enact a data protection law. But what good does that do if at the very local level, and even in terms of, let's say, from a principles perspective, there is a very huge deviation in terms of how different countries have approached it. So we end up actually creating more, it's more cracks, more fragments. There's a more fragmented state of data protection now than has ever been in the context of Africa. In as much as we're talking about, let's say, data protection laws, you can see from an ease of doing business, it has never been as complicated, because we're all looking at it in terms of, let's say, digital trade. We are regulating the same subject matter, but we are regulating it differently. And we're talking about, let's say, harmonization. How would that now impact? Are we going to take a more, let's say, in the European aspect, there's the aspect where they had the directive, then they had the regulation. So are we going to have something that is sort of going to impose something mandatorily? Or are we going to have something that's going to guide from a principles perspective and leave the states with the mandate to actually decide how to sort of deviate depending on their context? So there are a lot of questions that are coming up, even in this particular context. And the funny thing is, it's also happening at the regional economic community level, because we also forget that the regional economic communities, in as much as the agreement was meant to sort of supersede, let's say, a lot of the provisions that the different RECs are sort of or have had over time, we also see some overlaps. Yeah, they have already provided for some of these aspects. So how does that also read and add on to the complexity? So we have the AfCFTA, we have the RECs, and we have the local laws. So it's a very interesting area, but I feel like there's also a lot of opportunity to see how can Africa approach it. Do we really want to take a more GDPR stance, where it's actually being regulated at that particular level, where we're talking about now their quote unquote FTA, or are we going to look at something that is more regional, looking at the different countries and seeing how they would sort of even approach it, even from a reciprocity perspective? There are very many concerns, because I find it quite interesting to even just see nuances, even within the texts of a lot of these quote unquote laws, which have even been drafted or modeled of similar laws, and how they sort of deviate from each other.
I like when you say that. During my postgraduate research, my supervisors asked me to whether I can talk about an African approach. I said, no, I will not even mention, because what do you say? What is an African approach? Who defines what an African approach is? Because when you look at that time, Malabo, when I'd started, when I was deepening my research, the Malabo Convention had, I think, only like 12 or 13 countries are ratified. So I think it brings that question: what is the African? What is the African way? And also the fact that we also have the African network of national data protection authorities that are trying to come up. But also the bigger question is, where do these authorities fall in within the AU pecking order? When you look at AU statutes, do they have a space where they can articulate the cell and set the agenda? But I think that's a question we'll see in the discussions about annexes. Emily, there's a question that was on the chat that I want you to look at, is that the issue of competition. I think the dominance, you had mentioned it, but I think we need to unpack this. There's potential for dominating actors. And this protocol seems to shy away from talking about issues of dominant players, competition. And what really ought to happen? Let's talk about the ideal. What will be the ideal situation?
Thank you so much. I'm going to very briefly just said on data protection, because I think what's really interesting is just the wording that is very classic in the provisions on cross-border data transfers, which is this notion that where governments intervene or maintain measures that are inconsistent with the objective of data flows, it should not be greater than required. Like the measure should not impose restrictions greater than required to achieve the objective, right? So if you're going to put in a measure, for example, in the name of data protection and privacy, it should not be greater than required to meet that objective. But the question is, who decides, right? So it's a little bit your question here. And what I think a lot of the concern is that if it's then a trade panel, it's a group of trade lawyers that are going to decide, they may well decide that there are other options. For example, when companies take a voluntary approach in sort of self-regulation, that's sufficient for meeting consumer privacy laws, right? That's the US approach. So I think, again, it's really being quite, and we're going to see the devil in the detail because it's going to be in the annexes. But to what extent, how do you prove that your measure is basically not greater than required in terms of the restrictiveness? Does that make sense? So I think there's the language and the ambiguity, and then who gets to interpret? Is it going to be your data protection experts and your privacy lawyers, or is it going to be trade lawyers who are generally minded to try and make sure that trade can flow and that
or politicians
or politicians
or politicians to decide?
But that's the reason that the EU has been very careful not to make this, not to agree to this type of language, right? So they want to make sure that it's the data protection becomes the paramount priority, not the trade liberalization aspects of it. So I just think it's worth thinking about the hierarchy of, as you've said, of these obligations. On the competition one, I think it's really interesting. So digital markets are incredibly complicated for competition and antitrust lawyers because the traditional rules that we've had don't really work. So that's the challenge, right? So a lot of these products are provided for free. So just the ways that we figure out what market dominance looks like and look to discipline it often don't work in digital markets. There's been a big rethink among competition lawyers, and I'm certainly not one of them, but I do know that this conversation is ongoing about how do you think about market dominance and how do you discipline it, and what are the types of practices that we should be outlawing. So for example, self-preferencing of products. So if you're both, and this is some of the ideas under the DMA, the Digital Markets Act in the EU. So to ban some of the types or prohibit some of the types of mechanisms digital companies are using to essentially ensure they've got market dominance, right? So I think what you would want to see, there's quite a lot of consensus, I think, about the types of behaviors you now want to prohibit digital companies from pursuing. They could be in a trade agreement, right? There's no reason to say why we don't have a commitment in there that says we agree that the following anti-competitive moves are deeply problematic, and we will all agree that they will be prohibited, right? So there's no reason not to have really robust measures in trade agreements to discipline some of these activities. We're just not seeing them anywhere, and there's literally nowhere. None of them are in there. Go on, Bertu.
Can I comment on it? Because I just wrote a post about it, and I'll share it with you, like with one of the antitrust experts, and that was the question we investigated. Why, like what like we know the EU position, but what was the US position on antitrust, and why we never had like these provisions, these discussions in the trade, like in the trade circles or in trade agreements or even in the WTO, like, you know. And one of the reasons was like, you know, US was opposing it. Like traditionally, US was very big on consumer welfare standard, and they were really concerned that like having these discussions in trade agreements would affect the domestic, like, you know, the discussions here in the US. But the US like discussion has changed now, as I said, since Biden administration. Since the Biden administration took the office, like the wheel has changed, and then there is this growing anti-monopoly movement, and now like we see that, like, you know, trade is part of the like antitrust, like discussion. I mean, antitrust is part of the trade discussion. Let me put it in that way, because, you know, antitrust tries to you know, addresses the domestic markets. You know, I mean, you try to control the domestic competition in the market, but you can't really empower these companies in trade agreements. You know, so it has like implications like for the global trade discussion. But US has been opposing this for so many years, and that's why like we never had that discussion in trade agreements. But we need to relink antitrust and trade, and I think it should become like antitrust should become like a part of this broader like trade conversation, because at the end of the day it's about market power. You know, you can't really control the power domestically if we are empowering these companies like in your trade agreements, and countries should need to think about that. And one more thing, like what Emily said about the exceptions, like, you know, that's why exceptions are very important. Like trade exceptions work for trade. Trade exceptions don't work for data protection. Trade exceptions don't work for privacy. Trade exceptions don't work for competition, because trade exceptions are interpreted by trade lawyers, you know, and they know nothing about data protection or privacy, and they don't necessarily care. You know, that's I think it's something we need to keep in mind. And it's very important, like what EU did with privacy was really great, but then they changed their position very recently, you know, and they introduced this like the same language like in their exception languages. It's very ambiguous, but I think we really need to have that conversation about the exceptions, because at the end of the day, we have the rules and what are the exceptions. And if you are introducing these rules in your trade agreements for whatever reason you think, but, you know, we should be very careful about the exceptions, and you know, and countries should really stop copying and pasting these exceptions from the outdated trade agreements like the TPP or USMCA, because like the technology has developed, and discussions have matured like since then. And one question for you guys, like, I'm really curious whether you know whether the national data protection agencies have been consulted in this process, you know, while EU was negotiating this agreement. Have they consulted the national data protection agencies? Have they talked to the privacy experts? Have they talked to the AI experts? Because I know that there are all these efforts in Africa, you know, to you know, to come up with like national goals and strategies. Have you guys been consulted?
I do have a question about the national agencies, but I think linked to what you've just said, Boju, there was a comment here from Alison Gilwald from RIA, who said, despite internal consultations in the AU, the digital protocol severely undermines the progressive and enabling provisions of the African Union data policy framework, which tries to create harmonized environment for the safe and secure cross-border data flow in support of a single market, but also seeks to create preferential conditions for African countries, companies, and citizens in terms of creating fairer competitive environments and redressing asymmetrical data extraction from the continent. So if those who are inside the AU, who are drafting the AU data policy framework, had internal consultations, but was still undermined, then I don't know. And maybe that sort of gives us a hint of what happened.
Well, yeah, I mean, my argument sometimes is always that if you're not in the hierarchy, if your name or your name tag is not on the table of those making those decisions, then ideally you're not there. Because when you look at the hierarchy of the AU, I mean, even perhaps our colleagues who are working on the data strategy at the AU, and they're not at the table because the AU statutes do not provide them that opportunity to be at the table and make those decisions, and it becomes a problem. There's another question here, Melissa, since you're with the here. The issue of duties, custom duties, I think, or excise taxes. I think there's where in the protocol it talks about that there shall be no custom duties or custom taxes imposed. And there's somebody who had asked, what does this mean, and what effect will it have? No tax on digital goods and services.
I think I want Emily to answer that question. I think it's similar to the question about source code, because that's my area. If I talk about intellectual property, right? The provisions, and that's why I said the protocol is comprehensive but also vague at the same time, right? The question there in terms of customs is it's quite prescriptive. There are things that are quite prescriptive about it should not apply. There's also a question around. There's a whole blank part that was left blank, and I think this is where there's a lot of back and forth, I think, from the negotiators who are involved. Anything that raises customs tariffs is a touchy subject, so they will probably want to have a separate discussion for that, and it would delay the protocol, and maybe they will want to have that discussion separately. I don't want to comment on customs because that's not my area. My area really, or what I think is similar, is what is happening with the source code, where they say that it should be open. I mean, there's open source, there's a provision for open source, but at the same time, they say that you should not force people to open their source code, but at the same time, there's an objective of transparency and ensuring data protection and data governance. That just tells you, gives you an idea of what's happening. I don't have an answer for the customs one. I'm going to throw that to Emily. That's really not my area.
Sure, Emily.
Yeah, sure. So I think as the question, I think Daniel's question, I think he rightly intimates that there's a big dispute at the WTO, right, about this. So there's there's quite a group of countries that essentially have been saying they don't want to see a permanent moratorium on customs duties on electronic transfers. So this is part of a much wider debate. And I think the question is, so at the moment, there are temporary 2-year stays, right? So there's a temporary moratorium that keeps getting renewed every 2 years at the World Trade Organization. And the question is whether what's happening now with Article 6 in the African Digital Trade Protocol essentially undercuts the position of those same countries in the WTO. It doesn't necessarily, because it's clear that Article 6 applies to customs duties on products coming from other states, i.e. other parties to the agreement. So in principle, it's about not imposing customs duties on electronic commerce within Africa. But the question is more, I think, a tactical one of whether then it undercuts them at the WTO, because they've taken a principled position that they're not prepared to make the same position in the WTO, if that makes sense. So I think it's more of a tactical negotiating one. And what's interesting, I think it's RCEP, where there's language there that says without prejudice to our position at the World Trade Organization. So it's a really interesting move where they're basically trying to make sure they can liberalize on the terms they want vis-a-vis customs duties, but not undercut themselves at WTO. So it's a tough balance. And I think the RCEP language might be quite an interesting one to have looked at to try and square the circle. Does that make sense, Ogambi?
Yeah, I think so. And yeah, it does. And I just want to go back now to the issue of source code that Melissa asked. And I want to ask Jay this, because around the world, we've seen, I mean, in the US, we've seen FTC, we've seen the EU question the issue of source code, because it also issues the issues of algorithmic bias, the issues of digital harms, etc. So then if we can't investigate these harms, what does it mean? Jed, and perhaps Melissa can add, if you have something further to say. Jed, so what does this mean? Does it mean that if in Kenya, we've seen that there have been these court cases, 2 against Meta, the one that questioned the algorithms and how that was done in Ethiopia and how it contributed to the war, in Ethiopia. There's the same question in terms of Myanmar and the Rohingya Muslim. So then if countries really can't interrogate this source code, then what does it mean for digital persons or for our digital rights and digital harms?
Okay, thank you for that. And maybe I'll also pose it as a question. I know Melissa is also quite passionate about this. So is there a way we can strike a balance? Because you see, we have different actors. Definitely, we're not saying that, say, the data subjects or the individuals, perhaps their rights ought to be compromised. But how do we sort of ensure that their rights are being protected, but at the very same time, we are not compromising the source code of, let's say, the different entities that have actually developed some of these products or some of these programs, because we're looking at it in terms of there's a lot of work that goes about even developing the source code. Yeah, so there's the intellectual property aspect. There are some bits that perhaps some entities might not want to disclose. Yeah, so in that particular instance, so how do we protect that and also balance the rights of, let's say, the individual? Because I feel like I found this protocol to be too busy. There are too many things which are being discussed at once, and I feel like this was one of those opportunities for us to be able to, let's say, focus on things such as maybe source code and let's say a greater ambit, and some things which go together, and segregate some would have been very helpful, because all the experts would be in the table. So for that particular one, I feel as though the depth in terms of even the assurances that ought to have been guaranteed, and even at the point at which the exemption was being provided, that, oh, in investigations, this can be disclosed, this can perhaps whatever, that would be very important, but it cannot stop where they've left it. I feel like this protocol covers too much, but the helpful guidance that ought to have gone into it is not there, because we do know what they're talking about. But when you looking at it practically, what does it mean? How do we also sort of even strike that balance and say that in these instances, this is not going to be disclosed. In these other instances, this is the way we'd actually go about it, where, let's say, the exemption applies. I feel like there's too much about everything, but the depth in terms of even how the procedural aspect to play out, it's not clear. And I think that would be most helpful than just providing for the substantive bits, but not providing for how do we actually go about this? How do we also go about balancing it? What are some of the things that could actually, what balances would we have to strike when we're talking about the rights vis-a-vis, let's say, the protections of the source code? There's too much that I think ought to have been built into, and perhaps an approach that I had hoped was seeing how even some of these things would have been expanded or even split in terms of how they'd actually be provided for, even under different protocols. Melissa?
Thank you, Jade. I think this goes to show that there was definitely some interest that were involved in the negotiation of the protocol. It's curious to see that Article 5 has been left for another annex, but source code is a particular article under fostering digital trade, right? Because I don't think that there's a direct correlation there between source code and fostering digital trade. So it's curious as to why it has been included very particularly and prescriptively in this text. That's my question. And it's not even really mingling well. If I would have thought maybe it's about emerging technology, it's not even mingling well with that subject area. So it's very curious to me. Secondly, it goes above the other provisions for intellectual property protection. It's really about proprietary rights. It's including proprietary rights there. We are saying that even individual companies or individuals are not, legal personalities are not allowed to be in the dispute settlement resolution procedure, but here we are covering them by saying that source code will be protected, because who owns source code? That's the first question you have to ask yourself. Who does this actually protect? Because that gets us into the conversation of how will digital infrastructure then be developed? How are Africans really taking place in digital trade? So that first part of Section 24 is really curious to me. And the second part is not enough, as Jade has said. How by the time you get to investigating at the AU level, by the time an investigation is done and all this has done, then other fundamental rights have already been harmed in favor of a proprietary right. So there's no balance. There's completely no balance there, and it does not make sense to include it there, other than there was high-level lobbying of those who have proprietary rights in source code to include it within this protocol. It also could be an indication of a copy-paste mechanism, because we did see this in former texts between, for example, the US-Kenya FTA. There was this text that was included. Probably it's a copy-paste and text which has already been abandoned. So it even goes beyond the World Trade mechanisms. It goes beyond TRIPS. It's TRIPS plus. So it's just curious to me that, wow, we have gone TRIPS plus in this area, but in customs we've said, okay, we are going to first negotiate this further, right? And that's why I was bringing it up at that moment, because you have to look at it, that juxtaposition. How is it that you're so clear in your mind about source code, but these things about customs, you don't want to have a conversation of it in the text. You don't want to be prescriptive about it in the text. Those are questions that I think I'd like to ask those who negotiated.
Thank you so much.
Can I chime in, because this is a very interesting conversation.
One minute. Let's 30 seconds.
I mean, it's a copy paste from the USMCA. I can tell you that it's exactly the same provision from the USMCA. But you mentioned you highlight a very important issue there. This is a TRIPS plus provision. This is a TRIPS plus trade secret protection, and we don't have trade secret in the TRIPS because they didn't want to mention trade secrets in the TRIPS. So they came up with this as source code algorithms, and the scope goes beyond that. But it's the TRIPS plus provision, and it comes with no exceptions, because we don't have exceptions in international law for trade secret protection. Most of the countries don't even have trade secret protection because it's not in their legal systems. So this is a discussion we need to have in domestic level, and it's also an IP discussion. But unfortunately, they put this in trade agreements, and now it's becoming a rule, because every trade negotiator is so interested in this TRIPS plus, trade secret protection rules in free trade agreements.
Yeah, thank you so much. We have 4 minutes remaining. Thank you, Emily. Thank you, Melissa. Thank you, Burja and Jade, for that great input. I think I've tried as much as possible. Some of the questions that were on the Q&A were a bit similar, so I hope I trust that we've covered most of them. But I think what is critical now is the issue of the annexes. What happens with the annexes? The issue of ambiguity, the imbalance between what Melissa has explained, the TRIPS plus and the WTO issues relating to customs, and where does this leave the African person? Because they will be the consumers, or the people who will be accessing these digital goods and services. So I just want to give 1 minute each. We can start with Emily, a parting shot on what you see as the way forward, or any encouragement that you may have for us who are within the continent and working on this issue. So we'll start with Emily.
Thank you so much. So I think my 2 cents on this is, let's keep talking. I think it's really important to keep dialogues like this going and to keep kind of public interest at the forefront, because a lot of these discussions are dominated by relatively few large industry, because they're the ones who really understand what's at stake for them, and they've got a huge, as we've intimated, an outside influence over what's going into the type of rules that are being promulgated. So I think trying to get more voices in and to try and really think through where the public interest lies is vital. And we haven't mentioned, but workers, right? So the labor movement and workers are really important in this as well. So on the algorithmic transparency on source code, we're getting more and more of workers are basically being managed by algorithm, if you like, and that ability to hold that algorithmic decision-making to account is not only important for consumers, but also increasingly for workers. So to make sure that trade unions are also understanding what's at stake and that they've also got a voice in this.
Thank you for mentioning that, because in Kenya, there's actually a case, there's actually a matter a suit that is in the High Court about digital workers, and they're arguing about their work conditions, their remuneration. So I think it's also a big issue, and I think that's a huge gap in these discussions. Jade, 1 minute.
Thank you, Mugambi. So I think I agree with that. This is a rolling discussion, and I know we are all very interested in seeing the shape or perhaps the circumstances and the text that will actually shape now the annexes. Yeah, but definitely I know there are quite a number of concerns, but I think it's also a very good step because I know this is one of those protocols we've been really waiting for. So I think it's a step forward, but I'm hoping it will also not be 3 steps back in as much as perhaps we are talking about, let's say, having a protocol in place. Over to you, Mugambi.
Thank you so much. Yeah, the question, will we get a seat on the table across the continent? I think Buju and Emily mentioned the fact that sometimes it's just the trade lawyers speaking to themselves, sometimes it's just the privacy lawyer, sometimes it's just the politicians. And then there's that larger question, where are the national data protection authorities in this conversation? Buju, your concluding remarks? 1 minute.
It seems that the text from February is conclusive. So, I mean, they might be it sounds like it's the final text, but there are the annexes, and I think annexes are very, very important. And I think let's take this as like African awakening moment, and talk about this issue. And I think the conversations like this is very, very helpful, and inject the public interest in trade. I mean, that's the missing component in trade discussions, public interest. And as Emily mentioned, the trade is not only about the corporations, it's not only about the consumers, but it's also about the workers. It's also about the citizens. And in the case of this protocol, it's about Africans. It's about African people. And what's good for big US tech companies is not necessarily, it's not good for Africans. So I think as Africans, you should really, you should really go for your seat at the table and demand the seat at the table, because this is about African digital economy, and you should really have a say over what's best for Africa. So that would be my 2 cents. Let's inject public interest in trade discussions.
Thank you so much for your contribution. Melissa, our host today.
Co-host, because we are co-hosting with you, Dr. Laibuta. I think I want to say that I have not given up on an African approach. I definitely have not given up on that. I think it's possible to have an African approach. Every time I've been thinking about or looking at free trade agreements since time immemorial, because I'm an old person, I've been saying that we need to have collective bargaining power as Africans in order to negotiate free trade agreements. And I think getting it right at the AfCFTA level will create a precedence for how we will negotiate with other third parties. So great, it's wonderful that we are here. We can see where the teething problems are. We can see where we need to consolidate more. And we have a roadmap to do that. I think the question is about capacity building to ensure that those who are negotiating understand what they're negotiating. It's about having conversations openly and freely and transparently, which is actually within the protocol itself, about transparency, inclusion, all those words keep repeating in the protocol and in the agreement. So we are at a point here now where we are saying, okay, we have done an assessment, this is where we are at, these are the steps that we need to take to get to an African approach. So an African approach is possible. Those of us who are on this panel, 3 of us here are Africans, and we have opined about this protocol, and we can continue to opine, and hopefully our voices can get to the right rooms.
Thank you so much. Thank you to CPIT and the Data Privacy and Governance Society. Thank you, Emily and Buju, Jed and Melissa, for gracing us and sharing your thoughts on this issue. And we look forward to further conversations. And for those, I think a recording of this session will be shared for everyone who was not able to join for the full length. So thank you so much, and I hope the conversation continues. I think for me, the issue of the data governance, that is quite critical, and the disparities between what the protocol dictates and national level, because sometimes we talk about national level and it's a constitution. And so you find that a digital protocol is ousting the provisions of a national constitution. But yes, thank you so much. The conversation continues. Thank you for joining us, and have a lovely day, have a lovely evening, have a lovely morning, wherever you're listening to us from. And kwaheri. Thank you.
Thank you. Bye.
Bye.
Thank you. Bye, everyone.
Bye.